This is Michael Popak. We got a breaking news and a little bit of a shocking twist in the Supreme Court ruling in favor, by and large, in favor of Armando Abrego Garcia, who for the last 26 days has been rotting in an El Salvadoran jail, even though the government has confessed and admitted that they violated his due process rights and they violated an order that he remain in the United States and not be shipped to El Salvador that was issued by an immigration judge in 2019. The shocking twist here is it looks like this was a 9-0 decision where everybody on that court, even the liberal moderate wing, got together and agreed on the order language. And let me just distill it this way. Not one justice of the United States Supreme Court has ordered that the Trump administration bring Armando Abrego Garcia back to the United States. This is not a decision ordering his return. It is a decision supporting the Judge Zinnis's language that the Trump administration do everything in its power to, quote unquote, facilitate his return, not effectuate his return. Facilitate versus effectuate, words matter. And my words hopefully will matter a little bit here on Legal AF. Let's dive in to the new ruling. Two concepts can't possibly be true. When the new order came out, Armando Abrego Garcia's lawyers jumped for joy and said, the rule of law prevails. Let's get him home. Get him home. On the exact same time, the Department of Justice declared, and we'll put it up on the screen, that this was effectively a ruling that somehow benefited Donald Trump. I don't see it in the least, except in one area where they didn't order his return. But in every other way, they supported the due process constitutional rights violation analysis of Judge Zinnis below. But here's, of course, trying to make lemonade out of bullshit. Sorry, I'm not sure that's the phrase. Here's what the Justice Department tweeted out right after the ruling. As the Supreme Court correctly recognized, it is the exclusive prerogative of the president to conduct foreign affairs. By directly noting the deference owed to the executive branch, this ruling once again illustrates that activist judges do not have the jurisdiction to seize control of the president's authority to conduct foreign policy. Okay. This case has nothing to do with foreign policy. The only reason there's a foreign policy connector to it, or any kind of nexus with foreign policy, is because Trump decided to delegate and offload his responsibilities to retain and maintain the custody of the people that are in a immigration deportation mode. He offloaded that to El Salvador and paid them $6 million to take these people. That's the only foreign policy. What, that they negotiated a contract to effectively lease the El Salvadoran jail for the U.S. government? That's foreign policy? That's not foreign affairs. That's what Sotomayor said in her. I want to read to you. Now, when I say a dissent, there's no dissents. I want to make this clear. There is a statement by three justices, Sotomayor, Kagan, and Ketanji Brown Jackson. It's a statement. They agree with how the ruling came out. That's unsigned. We don't know who signed it. And they're not dissenting. They just think it could have gone a little bit further. But here's what Sotomayor says that the other two justices agree with. Here's what she says. The government's argument, moreover, implies that it could deport and incarcerate any person, including U.S. citizens, without legal consequence, so long as it does so before a court can intervene. Citing back to the case from 3 days ago, Trump versus JGG, in which they found effectively that Donald Trump can use the Alien Enemies Act to deport people. And if you want to object to it, you can't do it in a regular federal courthouse. You got to go down individually with a writ of habeas corpus and go do it in an immigration court. And let me read to you now from the majority decision, but I wanted you to keep that in your mind. 9-0, they're okay with not actually ordering the Trump administration to return Abrego Garcia, but they're going to have to facilitate. They don't have to effectuate, but they got to facilitate, and we'll walk in the difference of that. It starts with the order from Judge Zinnis way back on April 4th. This is what all this is about. She said on page 2, paragraph 2 of her order, Defendants, the Trump administration, are hereby ordered to facilitate and effectuate the return of plaintiff to the United States by 11:59, Monday, April 7th. Now, when they wrote the order on the Supreme Court, the opinion of the Supreme Court, they said, well, we sort of granted Trump's motion for stay because the Mondays passed last week. But in every other regard, the order of Judge Zinnes applies. Now, listen to the words of Judge Zinnes, because this is what the 9-0 of the Supreme Court supports. And this is the part that Donald Trump completely ignores in his rendering, his version of, hooray, they supported our foreign affairs power. Listen to what the judge said, because this is what's being adopted by the United States Supreme Court. Paragraph 3 of her order from April 4th on page 2. This preliminary relief, that the temporary restraining order, preliminary injunction, is issued to restore the status quo and to preserve Abrego Garcia's access to due process in accordance with the Constitution and governing immigration statutes. I have to do this in order to preserve his access to due process in accordance with the Constitution and governing immigration statutes, all violated by Donald Trump. Here's an example of the Supreme Court supporting, finally, out of 10 applications, supporting a federal judge, lower level judge, who Donald Trump has called a leftist, who Donald Trump has called a Marxist, who Donald Trump or his people around him have attacked and said is corrupt and unhinged and rogue. Supreme Court has supported Judge Zinnes. There's no other way to look at this. Now, where are they getting their ridiculous "we won" aspect? Let me read to you from the majority decision with a statement by Sotomayor, Kagan, and Jackson. Not a dissent, meaning it looks like it's 9-0. It's hard to tell because this came up through an emergency application and it's not on full briefing. And they issued effectively a per curiam decision or a per curiam statement that we can't exactly tell who's in the majority, but it looks like it's 9-0. Even Sotomayor, Kagan, and Jackson issue a statement that they would have gone slightly further, but even they're not ordering the return of Abrego Garcia. So here's what it says. On March 15, 2025, the United States removed Kilmer Armando Abrego Garcia from the United States to El Salvador, where he's currently detained in the Center for Terrorism Confinement. The United States acknowledged that Abrego Garcia was subject to a withholding order forbidding his removal to El Salvador, and that the removal to El Salvador was therefore illegal. Key point, they already confessed that they did something illegal, which is exactly what Judge Zinnes said in her hearing. Now remember, the lawyer that told the truth and consistent with his oath of to uphold professional responsibility has been fired effectively by the Department of Justice. Mr. Ruveni no longer works the Department of Justice, but he told the truth, and that is a key point. It ends up in the first 3 or 4 lines of this decision. The decision continues. The United States represents that the removal to El Salvador was the result of an administrative error. These are the facts. Administrative error. He was the subject to a withholding order forbidding him going to El Salvador. He was removed there. It was illegal. This drives the decision-making of the Supreme Court. Or as Abrego Garcia's lawyers said in their own brief to the Supreme Court, this case is one of one. Nobody else has this set of facts, this Kafkaesque set of facts, except for Abrego Garcia. The opinion continues. On Friday, April 4th, the United States District Court for the District of Maryland, that's Judge Zinnes, entered an order directing the government to, quote, facilitate and effectuate the return of Abrego Garcia to the United States by 11:59 Monday, the April 7th. The application is granted in part and denied in part, subject to the direction of this order. In other words, the application to stay Judge Zinnes is sort of granted in part because the Monday passed, but in every other way, here's what the court said. The rest of the district court's order, and I read to you the two parts of it, right? Facilitate and effectuate the return, and as she said, I need to do this to protect the due process rights and to make sure immigration law is being followed. They agree with that. The rest of the district court's order remains in effect, but requires clarification on remand. Remand means they're sending it back down to Judge Zinnes, who retains jurisdiction over the case, and with further instructions from her bosses at the U.S. Supreme Court. The order properly requires the government, the opinion recites, to, quote, facilitate his release from custody and to ensure that the case is handled as it would have been had he not been improperly sent to El Salvador. The intended scope of the word effectuate, however, is unclear and may exceed the district court's authority. The district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. For its part, the government should be prepared to share, meaning share with the court, the trial court, what it can concerning the steps it has taken and the prospect of further steps to facilitate the release of Armando Abrego. In other words, they can't stand now in front of Judge Zinnes and say, we didn't make the phone call. Trump, exercising his foreign affairs power, decided not to pick up the phone. We didn't contact, the Minister of Justice through our Department of Justice. We didn't do any of that. They're going to have to do some facilitating. The order, therefore, is entered. Okay. Before I read to you from the statement by Sotomayor, let's do a brief breakout of effectuate and facilitate from a legal standpoint. Facilitate means you do everything in your power to grease the skids in order for that another entity, a third party out of your, not completely under your control, to do their part to accomplish something else. So if it's effectuate the return of a book from a library, but the library book is being held in the library, but you have to facilitate its return. You got to make the phone call to the librarian. You got to bring your library book. You got to pay whatever expenses or dues or fines that are due for an overdue library book. You got to show up at the right time. You got to set an appointment. You got to show up at the appointed time and place. And you got to ask the right people for the books so you can check the book out, right? That's facilitate. Effectuate means you break into the library when all else fails and you pull the book off the shelf. Here, with Armando Garcia, facilitate means that the Supreme Court and now Judge Zinnes is going to require that Trump and his administration do everything in their power to use entreaties, words of love, words of diplomacy, whatever you need to do, fill out whatever form they need to fill out, push whatever button, make what other phone call to facilitate his return. And even if he's not returned, they have to give him due process and notice, which is a little hard considering he's sitting getting his 3 squares with no shirt on in an El Salvadoran prison. So that's facilitate. What they don't want and they don't like in the order is the word effectuate. And what they set up a little bit of a line in the sand, which Trump, of course, latched onto as a life preserver. And they said, well, so just be careful, Judge Zinnes, when you use the word effectuate, you may be crossing over into a world where a federal judge cannot order a president to do certain acts, or to take certain acts within the sphere of foreign affairs. That to me means if after they do all of the facilitating, the El Salvador still won't pop him out, they can't be held responsible after facilitating with getting him out if El Salvador somehow refuses. They don't have to effectuate the return. They don't have to break into the jail and pull him out, but they got to do everything else short of that. So this is what they've said. And they've said that for its part, the government should be prepared to share with Judge Zinnes what it can concerning the steps it's taken to facilitate his return and the prospect of further steps. Like, we are going to do more steps. For them to stand there and fold their arms and say, you're a leftist judge and we're not going to abide by you, that's over based on this ruling. They're empowering Judge Zinnes. Now we got to see what Donald Trump does with some of these weasel words that are used that he's going to try to drive a truck through. Like, please be prepared to share what it can with the judge. Well, they'll just say, well, I can't share with you, executive privilege, something like that. Here's what Sotomayor said. The United States arrested Kilmer Armando Abrego Garcia in Maryland and flew him to a terrorism confinement center in El Salvador, where he's been for 26 days and counting. To this day, the government has cited no basis in law for Abrego Garcia's warrantless arrest, his removal to El Salvador, or his confinement in a Salvadoran prison, nor could it. The government, this is on page 3 of her order, of her statement. The government's argument, moreover, implies that it could deport and incarcerate any person, including a U.S. citizen, without legal consequences, so long it does so before a court can intervene. Because every factor governing requests for equitable relief weighs against the government, I would have declined to intervene in this litigation and denied the application to stay in its full. But then the 3 liberal justices go on. Nevertheless, I agree with the court's order that the proper remedy is to provide Abrego Garcia with all the process to which he would have been entitled had he not been unlawfully removed to El Salvador. That means the government must comply with its obligations to provide Abrego Garcia with the due process of law, including notice and an opportunity to be heard in any future proceedings. See, I don't like that part. It should be now. But, again, even the liberals sometimes go a little bit off track. It must also comply with its obligations under the Convention Against Torture, which we are a signatory to. And at the end, she signs off with Ketanji Brown Jackson and Kagan by saying, in the proceedings on remand before Judge Zinnes, the district court should continue to ensure that the government lives up to its obligations to follow the law. Now, look, I'll end it this way. This is not a win for the Trump administration. The fact that they recognize he has some foreign powers and foreign affair powers does not mean that's a win. The takeaway from it is the court has empowered the trial judge, has said that she has subject matter jurisdiction, says she has jurisdiction, said she was right in her decision to order that the Trump administration attempt to facilitate the return of Armando Abrego Garcia. They just stopped at the water's edge and said, what did you mean by effectuate? But you better clarify that when we send the case back to you. And don't go so far as to cross over into foreign affairs. But otherwise, you were right as rain, and that's our ruling. Now we're going to see what happens in new proceedings in front of Judge Zinnes. We'll follow it right here on Legal AF. In the meantime, hit the subscribe button. I'm Michael Popak, and you're on Legal AF. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.